I beg to mention item number 18 of today's list, Your Lordship. I am not pressing this petition. I have instruction not to press.
As Bottagood, the learned counsel appearing on behalf of the petitioner, submits that he has instructions not to press the instant writ. Accordingly, the instant writ petition stands, while interim order so passed stands vacated.
Okay. Therefore, moving an unlisted, my lord. Highly obliged, my lord.
Your lordship. Your lordship. Lordship, to hold the brief, but. Lordship, item number 3, no longer hold the brief for the petitioner. The name has been wrongly checked in the cause list. Lordship, I have informed the registry. I made it.
We'll see when the matter is doing. Has the clients who are taken back the brief from you? Have you filed an affidavit to that effect?
Lordship, made an application. I have informed the registry.
We'll see when the matter is taken up.
Wait, please, Your Lordship. Your Lordship, this morning we have filed our affidavit in reply in item number 16 and 17. Therefore, Your Lordship, I pray for the requisition of the same.
Why?
Your Lordship, the matter is fixed today, and this morning only we have just filed our affidavit in reply. So,
Get it. Get the affidavit in reply and on record. Where is the question of accommodation?
highly obliged, Your Lordship.
Huh?
Your Lordship, item numbers 24, 25. Lordship, the department was trying to negotiate a settlement.
Huh?
Penalty.
Department, what is the department doing?
PHE department, Your Lordship. They were trying to negotiate a settlement and meeting, they have not fixed a date.
Who is asking for adjournment now? Joint prayer. 24 to 29, 28. It has been submitted by the council appearing on behalf of the petitioner as well as the PHA department of the government of Assam that there is an attempt made for an out-of-court settlement. So, accordingly, the matter stands adjourned to be listed again on 23rd of September 2024. It is made clear that if no settlement is reached in the meantime, this court shall take up the matter for disposal on its merits.
Yes, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 42 of Lordship, matter may be taken after 4 weeks, after 2 weeks.
Huh?
Matter may be fixed after 4 weeks and
What matter is this?
railway a writ petition filed against Railway Claims Tribunal.
Railway Claims Tribunal, how is the writ petition maintainable? Other side has no objection.
Lordship, with the consent of the other side.
Interim order? Is there any interim order? The request of the learned counsel for the petitioner matter stands adjourned to be listed after 4 weeks.
Objective.
Hey, please, Lordship. So I beg to mention item number 54, Lordship, of this hearing list, Lordship. So I pray for some upgradation, Lordship.
54.
Yes, Lordship. Yep, urgency, Lordship.
Why these matters are, hearing matters are here?
Lordship, actually it was on the.
Oh, these matters,
Yes.
these matters pertain to what?
Regarding selling of a shop, Lordship, and only this was my earning source, Lordship.
Hmm?
It is a selling of a shop, Lordship, and it is only my earning source, Lordship. So Lordship, it is a sale, Lordship, and if their Lordship is and to the Lordship is completed 1 year, Lordship. So my whole earning source has been gone, Lordship. That's why Lordship, paying for some accommodation, Lordship. So,
Okay, we'll take it up after item number 55. Inform the other side. You want an upgradation?
Yes.
After 55, 55 is, will be taken up at 2. So after that,
I will go.
May I please, your lordship. Lordship, in item number 52, we have filed an additional affidavit. So that record may be called for today. Deeply obliged.
May please, your lordship. My lord, I would pray for listing of an WPC, my lord, which is pending, my lord. Last listed on 2/5/2024, my lord. Whether pertaining to my lord, grant of IMFL license.
grant of,
IMFL license, my lord.
okay. Have it on 6th of September.
My lord, can it be on 2nd of September? 2nd of September, my lord.
Okay.
I'm obliged.
Your Lordship. Lordship, item number 30 of the daily list. I had filed an impediment application, Your Lordship. It is not part of the record, Your Lordship. It may be called for.
Treatment of what?
And for a private respondent, Your Lordship. Last occasion, it was told that I need to implement it is a RTI application case. Where it was filed because the RTI information was not received, officer. But the land had been muted in the name of a private respondent, and he was not implicated in the case. As such, last time I was told that he needs to be implicated in the case. I had filed the
We
implementation.
have to adjourn it. We can't take it up today because that application is not there on the record.
May be taken up any other day. Your Lordship. Already filed it.
Item number 30,
30.
Sir?
Take a-
counsel appearing on behalf of the petitioner has submitted that an interlocutor matter again on 308/2020.
Obliged.
May I please, your lordship. Lordship, I pray for listing a writ petition for withdrawal.
Withdrawal?
Yes.
When do you want it?
Any that you have.
At the depot? Request taken.
Lordship, Lordship, I have another prayer, item number 31, your lordship. As per instruction of my clan, your lordship, matter has been infructuous, so I want to withdraw.
As per instruction of your client is what?
Infructuous, matter has been infructuous.
As per you, whether it is infructuous or not.
Lordship,
So infructuous, he can, you can say, he can't say. May not press, it's a different aspect. I can counsel appearing on behalf of the that the liquidity taking into account the conditions stands in term orders, if any, stands with it.
and lordship, item number 22, honorable court directed to file an additional affidavit. But I have applied for a document, but it has not yet been received, so I did not file the additional affidavit, so kindly.
Yes, if there is no additional affidavit, we'll take it on as it is. Yes, Ms. Coleman, what has happened? Okay. Done. Give a copy. Ms. M. Bormon, the learned junior government advocate, pursuant to the directions issued by this court on 9/8/2024, have placed before this court the order dated 17/8/2024, whereby the additional district commissioner, Porpeta, have concluded that the name of the petitioner and others should also be entered in the NOK certificate along with the applicant and others, and thereby cancel the earlier NOK certificate. The said order is kept on record and marked with the letter X. Mr. I.H. Loskar, F. M. Ahmed, the learned counsel appearing on behalf of the petitioner, submits that in view of the order passed on 17/8/2000, the instant contempt application. Accordingly, the contempt applications, your thing has been done.
Highly applies.
Amount has already been sanctioned. He has nothing. Now we will get the money whenever it needs to be paid. An instant contempt application was filed seeking filed alleging violation of the order passed by this court dated 8/1/2024, WPC number 473/2020. In the said order, this court directed the District Commissioner Kamrup Metro to disburse the amount of ₹2 lakhs to the bank account of the petitioner as per the sanction order dated 29/11/2023 within 30 days from the date of submission of the certificate copy. Full stop. In pursuance to that, on 17/1/2024, the petitioner duly submitted the said the petitioner then submitted the certified copy by way of registered post, which was duly received on 19/1/2024. When the instant contempt application was listed on 9/8/2024, this court inquired with, had sought instructions as to whether the directions passed by this court on 8/1/2024 in WPC number 473/2021 have been duly complied with by the District Commissioner Kamrup Metro. And in that regard, requested Ms. M. Bormon, the learned junior government advocate, to obtain instructions. It is seen that in pursuance thereto, Ms. M. Burman have placed before this court an instruction dated 16/8/2024, given by the Additional District Commissioner, wherein it has been mentioned that the amount of rupees 2 lakhs have been duly sanctioned and the same have been forwarded to the Revenue and Disaster Management Department for release of the payment. However, the budget allotment for the same have not been received by the DDMA Kamrup Metro. And on receipt of the same, the ex gratia payment would be immediately released to the NOK of the deceased.
So
The said instruction is kept on record and marked with the letter X. This court fixes the matter again. This court duly takes note of that the order was passed by this court on 8/1/2024 in WPC number 473/2021. After taking note of that there was a sanction granted on 29/11/2023. And in that regard, directions were given to release the said amount. However, the reason which have been assigned does not seem to be satisfactory. Accordingly, this court issues notice upon the respondent returnable on 6th of September 2024. The petitioner is directed to serve a copy of the instant order along with a copy of the writ petition upon the respondent by way of dusty routed through the registry of this court. On the returnable date, the respondent shall apprise as to why proceedings for contempt should not be initiated against the said respondent.
deeply.
Madam, ask your deputy commissioner from wherever it is to get the payment. Because it was mentioned before this court then that this amount was directed to be paid, will be paid immediately. And the budget sanction, I don't understand how it is not possible, because there had been one budget initially of March. Again, there is a present budget which have been happening. So under such circumstances, when the order was passed in the last financial year, it's not understandable why you don't have the budget. Yes, what is this?
This matter, Lordship, no longer hold the brief, Lordship, in return to the petitioners.
Yes, have you evicted them? Oh, have you evicted them? Show me a document by which they have taken back the file from you.
Lordship, I have my NOC. We have received, Lordship.
Who has received this?
Son of the petition number 1.
No, no. How can a son of a petitioner receive it? He is not a named petitioner. You have to argue now. Can't say that you cannot. You are under an obligation. This is not by which you can give up. There are therefore 40 petitioners. Of these 40 petitioners, who they have given a wakalatnama signing, giving you the authority to appear. And thereby you cannot say that I have informed. When those persons, none of the petitioners have signed it.
They've just taken the brief.
I can't help it. You can't, you should not have. If you have taken away the brief, somebody has taken up the, can you give a brief to any ABCD?
Lordship,
I would have understood that the signing is that of the one of the petitioners. You have taken the risk of 40 petitioners out here. They have signed the wakalatnama. Your agreement with the petitioners does not end, or your contract with the petitioner does not end. It continues. It has to be.
I have a soft copy of the page which they had given for withdrawal of the Vakanama.
No soft copy business out there. You can't.
Lordship, they have
No,
already,
nothing.
Lordship challenged the eviction process, and by order dated 6/8/2024 of this court, Lordship, the court has disposed of the matter, directing them to, Lordship, approach the authorities, Lordship.
Where? Here.
Lordship,
Who's the?
Lordship, not this matter, Lordship, in a parallel matter, Lordship, they
I'm
they
not
have
on
already challenged the eviction process, Lordship. If this writ petition was filed prior to that, Lordship, for consideration of a representation. WBC 3410 of 2024.
Matter, this type of matter I've already dealt with.
So August Lordship had already disposed of the matter, directing the petitioners to approach the authorities. They had challenged the eviction notice which was issued pursuant to this minute, Lordship.
And then, so nothing remains in this.
Lordship,
Where is that order?
Lordship, in WBC 3410 of 2024.
To order to let you. Oh, yes, I remember. Mr. Adhor was there for one of the, there was a fight between two persons, two advocates. No. There are two persons who wanted to appear for the Kabarstan. That was the response number 5 there. Yes, isn't it? I said out there that I'm not going into that dispute, if you am not. Isn't that the case? Yes. And what is the direction did I pass? So that is subsequent. And asking the district commissioner to decide that. Mr. P.K. Roy Chaudhary was the other side counsel. Huh? Yes, I remember. The one Mr. Adhor was representing, he was supporting you. And the other is being represented by other. Yes, this is it. So repetition খনৰ নম্বৰটো কি? It has been submitted by Mr. N. Goswami, the learned counsel for the state of Assam, that the instant repetition has become infructuous in view of the order passed by this court in WPC number 3410/2024, wherein the petitioners, there was an observation wherein the said repetition was disposed of, thereby granting liberty to the petitioners therein to file representations before the concerned authority who have issued the notice for eviction. Stop. This court have also perused the said order dated 6/8/2024, passed in WPC number 3410/2024, wherein the petitioners in which petition the petitioners herein were also parties. Taking into account the above, the instant repetition therefore stands closed as it has become infructuous. Madam, you are new, so be careful next time when you have 40 petitioners. You can't take up like this. You have to get the signature. First, taking up a matter also, you have to be careful. Because at the end of the day, tomorrow they may say many things. Where these people may say that we never entrusted anybody to withdraw. Why did she withdraw? Yeah. Yes, tell me what is this? That she will obtain instruction for any grant of cyclone. What is this? On time marriage should not be released to the in favor of the petitioners and after inquiry, if any is inquiry. Somebody has given some instruction. Yes, yes. Do they get it? Page 8. This is for cyclone. Why do you give this? This is under the national disaster. Regarding the list of revised items and norms for assistance of SDRF in the wake of natural disaster. Sector 1 is when they should exist. Now, as per this, recovery and reconstruction, 30% of the that is equal to 30 of the SDRF for the year. Fully damaged, destroyed house and really damaged Pakka 120. So you give some benefits. Obviously. This court is not going to give those benefits. Inquire and find out if they are entitled to, then give it. So, and what are the other people? Who are these people? From 7 to 12, who are these people?
Hello, actually their houses were destroyed, but the Lat Mandal and the authority, they are not taking their documents and all. That's why they approve this code.
No. What are, who are these? Respond number 7 to 12.
Uh, My lord, seven
Why?
one Abdul Awal, my lord.
Who are these? Respond number 7, 9 to 12.
Let's say, 7, 8 and 9, they are my lord, the Abdul Awal is Gaura, Abdul Munaf is Gaura, and Imran Hussain and Monirul Islam. They are getting the funds, though their houses were not destroyed. And my lord, Abdul Awal is the maybe large mandor here, my lord. Taken
Then you filed an FIR.
before the.
Now, what do you want? You want an inquiry
Yes,
against to respond number 7 to 12. And
they are not.
you want to get which, what do you want at the end of the day?
As our houses were destroyed, we want the fund provided by the government.
Ah.
So when the unauthorized, when the person's name include in the beneficiary list, but their houses were not destroyed, so we complained to the deputy commissioner,
You have filed an FIR.
FIR before.
What happened to the FIR?
In FIR, my lord, when we are not getting the funds, that time when we go to Latmandal and discuss about the things,
I understand you filed an FIR. What has happened there?
after that, my lord, they are not taking any action. And then I filed, my lord, one representation before deputy commissioner. But deputy commissioner action. My lord, before entering.
And after inquiry, if necessary, your lordship may be pleased to direct the respondents to it. But this is your prayer. Your prayer is only limited to 95,000.
My lord, yes, 95,000 they are getting. Other beneficiaries getting up to 95,000. That's why I'm claiming 95,000. And here my prayer is to finance department, my lord. I think it is the finance department who provide the funds. That's why I'm making here respondent number to finance department, my lord.
Finance, no finance. Who pays the money? The revenue. We do one thing. There are two things. I can either issue notice. Sense of notice, but that would be only to that extent, because if I dispose it off, you have to give up your prayer for inquiry against those people.
Notice my prayer, full prayer.
But you don't have the prayer for that to cause an inquiry against those. Because your purpose would be served if they come up with this thing, if you get the amount. Or do you want that those people should also be punished?
You notice, my lord, I said that the petitioner approached the private respondent discussed the same through the so they threatened them to use the slang language. Then getting no other way, petitioner approached before the deputy commissioner of Naga White French number dated French but going bench the
Because we
respondent,
issue notice then.
my lord,
Notice. This
Number
making it returnable on 25th of September 2024. His PR Mohanto appears on behalf of the N. Goswami appears for the respondent 3, 4, and 5. 3, 4, 5, and 6. Accordingly, this court directs that the counsel for the petitioner to serve extra copies of think the respondent number 1, 3, 4, 5, and 6. As regards the respondent number 2, the petitioner is directed to serve a copy upon the Standing Council of Finance Department. In respect to the respondent number 7 to 12, the petitioner is directed to take steps by way of registered as well as usual. The case of the petitioner's hearing are that the houses were brutally damaged on 15/4/2022. And as such, the petitioner claimed certain ex gratia payment on account of the scheme available under the Revenue and Disaster Management Department of the Government of Assam. It is the further case of the petitioner that the petitioners have been deprived of the said benefit, whereas the respondent number 7 to 12, whose houses have not been demolished, have not been affected, have been granted certain benefit by the concerned respondent authorities. In that regard, the petitioner have also filed an FIR, which have been registered and numbered as, what is the number?
But the FIR is not registered.
Have filed an FIR, which have not been taken note of, and also a representation before the deputy commissioner, which have also not been inquired into. The official respondents and the respondents herein are directed to bring on record their stand by way of an affidavit on or before the next. Let them do it. Respondent number 5, whether he does or not, that's what you can let them come up with the stand as to whether he submitted the representation, whether he filed an FIR. It is he saying. On record your stand.
My lord, petitioner is a CRPF personnel,
What person?
CRPF.
Yes.
He married the private respondent number 5. And she has filed 3 cases against me.
Ah.
But due to all these cases, my life became miserable. Then I pronounced 3 talaks. That is Talake Hassan. Talake Hassan means in 3 ministration period, 3 divorces are given. After 1 divorce, if the parties want, they may reconcile. And if the second time also, there is a chance of reconciliation. But third time, if it is pronounced, that it becomes final. There is no scope to be reconciled. So there is a law that lordship may kindly see this. The Assam Muslim Marriages and Divorce Registration Act 1935. Recently, the said act has been repealed by the Assam cabinet. But the present act has been completed prior to that repealment. So by virtue of exercising that power which this act has given, the act has given the power that as per section 8, the husband may pronounce talak in 3 ministration period, and thereafter that the same shall be produced, placed before the Muslim marriage register. Then Muslim marriage register will apply his mind as per section 10, as per section 9. Then as per section 10, as per section 9, that is his duties. But he will comply his duties as per provision of section 10. So here, my lord, everything has been completed. Lordship, I told Lordship kind attention, kindly see page 10.
Page
10, para 8, last part.
Hmm.
In this regard, it is worthy to mention here that the Assam Muslim Marriages and Divorce Registration Act 1935 has repealed by the Assam Cabinet, and the said has also been notified in the Gazette notification on 16/3/24. So this case has, the said act has ceased to exist after 16/3/24. But the present case of talak registration has been completed prior to issuing notification, that is on 24/10/23. So almost, my lord, 7 months earlier. So
When it has been completed?
it is completed on 24/10/23.
24/10.
Yes, 24/10 it is completed, and Gazette notification has come on 16/3/24.
Then what happened?
So now our duty is this, but after that, my lord, that has been given to the Kaji, and Kaji has also put his signatures. Thereafter, he has issued certificate, and thereafter it is put before my authority. But authority says, authority has sent the letter to higher authority. The higher authority has not yet come with with any answer. Kindly see now page 47, madam. This is my petition. Application seeking removal of wife's name from the department history and PIS data as talak. Divorce has been happened. So that application I have given, and thereafter, my lord, the authority has sent this letter, that is page 49.
Then
In 49, my lord, the DIG GC CRPF is saying that it is sent to commandant that number so-and-so, Constable BUG Rafiqul Islam of your office presently attached with this GC in next commando team individual submitted application for family details updating in PIS data, individual application forwarded to your office for your further necessary action, please. Now, this is sent to the commandant. Now, my lord, thereafter, the commandant has written a letter to the DIG, that is page 50. Operative portion may be seen, my lord, second para, page 50, second para. In relation to the above, you are informed that the employee has divorced his wife on 24/10/23 as per Assam Muslim Marriages and Divorce Registration Act 1935, on which Sri Rashidul Islam advocate sent a notice on behalf of his client so-and-so Rafiqul Islam to accept talaknama and divorce registration certificate, on which clarification has been sought from the office of the Deputy Inspector of Police Range CRPF Guwahati, whether Sharia law through Talake Hassan, Talake Sunna acceptable or not, right? Wireless number so-and-so, that is 24/11/23, 7/1/24.
So why have you approached this court?
Hello?
Why have you approached this court?
I have approached the authority
No, why have you are approaching this court?
because the authority is passing no order. Authority is passing no order. There are the letter of the, I submitted letter to my commandant. Then commandant sent a letter, DIG sent a letter to commandant that he wants to remove his wife's name from the list of dependents. Then, my lord, again, letter is sent to DIG police by the commandant. So these interdepartmental communications are going on, but they are not deleting the name of my wife from my dependents list. And I have two prayers, madam. Then for a moment, Lordship, I invite your Lordship, kindly see page 11, Lordship, kindly see. First priority, to respondent number 4, to act upon the application dated 1/2/24 for updating PIS data in accordance with the provisions of law within a timetable. The respondent number 4, to updating family details of the petitioner in personal
Returnable on
information system
25
and
nine
remove the name of petitioner's
2024.
wife.
Mr. RKD Choudhury appears on behalf of the phone numbers 1 to 4. Copies of the petition be served upon him during the course of the day. As the respondent number 5, the petitioner is died by way of registered. The case of the petitioner herein is that the petitioner have divorced his wife, who is the respondent number 5. And say proceedings, the said divorce proceedings to culminated on 24/10/2020. Thereupon, the petitioner sought for updating his personal. What is that personal?
Information system.
Personal information system data before the respondent authorities. However, the respondent
And also to
authorities
remove my
are
wife's name.
not taking any action on the said aspect. It is under such circumstances, the petitioner has approached this court by filing the instant petition. On the return, on or before the respondent returnable date, the respondent shall bring on record their stand by way of an affidavit. Huh? Yes, 25/9.
My lord, may I pray one thing, my lord? Pendency may not be a bar.
If you want that order, then should I dismiss it?
If we are on law, my lord,
No, nothing doing.
law is nothing.
Pendency has nothing to do with it. You are asking, invoking the jurisdiction of this court will take care of.
25/9.
Yes, what is this?
My lord, the petitioner's brother in the last year was murdered. And accordingly, he had lodged an FIR before the concerned police station. FIR is page 15, my lord. And that was registered under section 364, 120B and 30. But although, my lord, 1 year elapsed, my lord, investigating department was not doing the investigation properly. As such, he was compelled to approach before the learned magistrate seeking a direction from the concerned OC about the status report of
Hmm.
My lordship kindly peruse annexure F, page 35. The learned magistrate passed the order on 12/4/2024. Relevant portion is, my lord, by the said petition, the informant such and such has stated entirely that police has not shown any proper interest to complete the investigation, and that police has failed to arrest the actual culprits and to submit charge sheet in the case. The informant has prayed that the status report be called in connection with the instant case.
Then what
Peruse
happened?
The case, and the record shows that instant case was initiated on one affair, which was received on 6/8/2023. So it is seen that sufficient time has elapsed since the initiation of the case, and no report in final form has been submitted till date. Hence, this court deems it proper.
No, that I will look into. Now tell me, what is your case? Why should this court entertain?
Yes, my lord, yes. Even although the order was passed on 19/4/2024, Annexure G, page 36. Concerned judicial magistrate directed the IO to expedite the investigation and to submit report in final form as early as possible. But the IO has not taken any initiative till today. As such, he was compelled to approach before this honorable court to hand over that case to any other agency like CBI for the interest of justice to name the culprit, actual culprit.
Why? Why CBI? Why CBI?
Hello.
In your case, they are not capable. The Assam police is not capable.
One after another order is passed by the magistrate and directed the concerned OC to expedite the investigation. But the investigation has conducted in casual manner. So where to proceed? So the petitioner approached before this honorable court seeking justice, my lord.
To make the CBI a party, one has to, case has to be something of extraordinary nature.
Yes, my lord, since,
What is the extraordinary nature that the investigation cannot be carried out?
my lord, deputy,
Then in all cases where orders are not being complied with, should we give it to the CBI?
my lord, I am concerned with my case, my lord. My respectful submission before this honor.
Who is appearing for the respondents here, 1 to 4? Mr. Goswami, get your instructions on the next date, short notice, as regards the status of the investigation. Issue notice making it returnable on 28/8/2024. Mr. B. Goswami, the learned additional advocate general Assam, accepts notice on behalf of the respondent number 1 to 4. 4. This court, for the time being, is not inclined to issue notice upon the respondent number 5 and 6. It shall be considered on the returnable date. The case of the petitioner herein is that the brother of the petitioner who died, brother,
Yes, was the elder brother.
was killed. And in that regard, an FIR was lodged being Belsor PS case number 202/2023, which was registered under section 364/120B/302 of the Indian Penal Code. Taking into account that the investigation was not proceeding in the manner in which it should have been, the petitioner herein have approached the concerned jurisdictional magistrate under section 156(3) of the Code of Criminal Procedure 1973. In the said proceedings, the concerned jurisdictional magistrate had directed the investigating officer of Belsor PS case number 202/2023 to provide the status report by an order dated 12/4/2023. The thereby fixing 19/4/2024. Pursuant thereto, there was a direction, further direction on 19/4/2024 to the investigating officer to expedite the investigation and submit report as early as possible. However, as nothing was done thereafter, the petitioner has approached this court. The investigating officer of the Belsor police station, investigating officer in respect to Belsor PS case number 202/2023 is directed to produce the status report on the next returnable date and also apprise this court as to how long would be required for completion of the investigation. During the course, Dishuna, I've already given that.
Will file.
I have not issued notice. Will consider no appearance. If I have not issued notice, you have no appearance. Will issue later on. Unnecessarily don't trouble CBI so soon. Let's see what happens. On the next day you appear. Then we may consider. Or we will close it.
7.
Yes, what is this?
Sure.
Allegation of misappropriation of some funds, my lord. That if I lost a complaint before the police, that was not acted upon. And subsequently, my lord, he.
Is there a case against the private respondents in terms with the complaint case registered as so and so? Direction to whom?
Direction to respondent number 3, my lord.
Who is respondent number 3?
The superintendent of police, my lord.
Why?
First, my lord, before the superintendent of police also, the complaint was lost earlier. That was not acted upon, my lord. And then.
No, 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 no. You filed a complaint case.
Subsequently, yes, my lord.
You filed a complaint case
Yes.
before the jurisdictional
My lord.
magistrate.
My lord.
I think
Annexure-
process have been issued.
annexure 4,
Process have been issued.
my lord, the matter was remanded back to the police, my lord. The concerned, my lord, the officers in such, my lord. But despite that, my lord, no case was registered, no investigation done, my lord. Therefore, I am before your lordship.
Let's see that order.
Order, in fact, my lord, I could not furnish the order.
Huh?
I have explained. Your lordship may kindly peruse.
What?
My lord, paragraph 11, my lord.
No, 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 no. There has to be some order passed.
Yes, my lord, paragraph 11, my lord.
No, no, no. There has to be some order passed by the court.
Passed, my
What-
lord. The
where
order
is
was
it?
passed,
Where is that?
I could not obtain the certified copy, and why I could not, my lord, that I have
No,
explained.
no, no.
There are-
Why you could not?
Because, my lord, the court says that I have also, my lord, pressed upon petition, if your lordship is pleased to peruse, my lord, annexure 5, my lord.
What is that?
Yes,
Page?
annexure 5, page number, my lord, 31. Page 31, my lord. So this was the petition filed, praying for the certified copy of the order as well as the complaint petition. But the court did not furnish me, and.
What
the
is,
reason-
what was your application?
Application for, my lord, the order dated 8/12/2023, my lord.
No,
By which
how,
the matter
how
was
can the
remanded
court,
back.
court make it as a GR case?
No, my lord. No, because the
Isn't
court
that,
says,
mister? Is it possible? When a CR case has been filed, the court has to either issue notice. If I'm not wrong, nothing further can be done.
generally the
you should
practice is
process.
that, my lord, my lord, the court remands the matter back to the police, my lord, for investigation as well as registration, etc., my lord. So in this case,
So, no, that investigation would be limited to 202.
sometimes, my lord, finally disposes of, my lord, and
How?
they remand back.
How?
The-
Can they
the,
do so?
Magistrate court,
Can the court do so? Under the 200, when 200 proceedings under 200 is filed,
yes,
can the court do so?
because, my lord, the
Either
court-
issue process
yes, my lord,
or reject it.
of course. But in this case, and generally in other cases also, my lord.
No, no, no,
they remands
generally,
to the-
non-generally cannot happen. This seems to be a transgression to the infraction to the provisions of law. No, CRPC conducts. Can't be done.
Because with the similar grievance also, my lord, some other persons also filed the same CR complaint case, my lord. That was not done. So they also approached this honorable court, and this honorable court asked the government to take instruction, and on instruction, my lord, it came to be known that subsequently the police registered. the case.
No, CRPC conduct. No, 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 no. Nothing. If this is the action which they have done, then obviously then it will be a case of say under, you file a 482. I don't think the court can do it.
Because, my lord, generally they makes the observation that the police are required to make some preliminary inquiry. So
No, no. You see, the CR case has to be disposed of. If it is to be disposed of, there has to be an order. Without an order, it cannot be. Either the court may say that, look here, I'm not going to look into this,
Yes.
whatever may be. Kindly giving you the liberty or this to you. Or did it treat it like as an application under 156(3)?
Sure.
Because you categorically mentioned under 190. Then it could not have been under treated as 156(3).
for a moment, may I take your lordship to page number 33? Page number 33.
Yes.
Lord, some other persons also approached against the same respondents, my lord. that in second para, my lord, the order of the court passed by the learned magistrate, my lord, 8/12/2023. That this has the reference that the record was sent back to the police, but they could not trace out the record, and therefore they could not register the case.
No, it cannot be sent by the
I-
judicial magistrate.
That is-
No. When a proceeding is initiated under 200, the court cannot send it like this. It may exercise a limited jurisdiction of an investigation under 202. Nothing more than that.
Your lordship is correct. Either to reject it or to issue process.
Eh?
Yes, my lord. Generally the magistrate has to either to reject the petition or to issue process against the accused,
That's it.
but that is not
But
done.
he had no business. It may ask the police officer to make an investigation as regard this. Nothing more than that. But it is a registered proceedings. If that is a registered proceeding, then how is it possible? Because CRBC নাই. My goodness. কোনে লৈ গৈছে? We do one thing. Let us ask the registry to get the copy of that order passed in CR case from the judicial magistrate.
My lord, that would-
Then things will clear. Then we take up.
Yes,
Because you can't do this.
of course.
So let us see what the court can do.
Yes.
See, CRBC. If in the opinion of the magistrate taking cognizance of an offence, there is sufficient ground for proceeding, the case appears to be summons case, he shall issue summons to the AI, warrant case, he shall issue no summons AI. This is 204. 200 examination procedure by magistrate not competent to take cognizance. If the complaint is made to a magistrate who is not competent to take cognizance of the AI, he shall, if the complaint is in writing, return it for presentation to the proper court with an endorsement to that effect. If the complaint is not in writing, direct the complainant to proper court. Any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made over to him under section 192 may, if he thinks fit, and shall in the case of so and so postpone the issuance of process against the accused and either inquire into the himself or direct an investigation to be made by the police officer or by such other person as he thinks fit for the purpose of deciding whether or not there are sufficient grounds for proceeding. So his investigation is only limited to 202. If that be so, he cannot dispose of the matter in this manner, sending it to the police. They go, police, you do whatever, raise an FIR. No. Let us see what order has been passed. This is something serious. And if this is the proceedings followed. Issue notice returnable by 31st of August 2024. Mr. N. Goswami appears on behalf of the respondent numbers 1 to 4 and extra copies of the writ petition be served upon him during the course of the day. For the purpose, for the present, this court is not inclined to issue notice upon the respondent numbers 5 to 10, which shall be duly taken into consideration on the returnable date. This court have duly taken note of that The petitioner herein had filed an application under section 190 of the Code of Criminal Procedure, read with section 200 of the said code, praying for taking cognizance of an offense committed by the private respondent numbers 5 to 10. The said case was filed before the Judicial Magistrate First Class, Kamrup at Boko, and was registered as CR case number 51/2023. The learned counsel appearing on behalf of the petitioner submits that 51 or 49,
51, my lord.
51, na? 50, submits that the judicial magistrate, the concerned judicial magistrate, upon filing of the said complaint, referred the matter to the
OC Boko PS.
Boko police station for registering a case and filing registering a case. This court, taking into account the difference under section, an investigation to be carried out under chapter Roman 12 of the Code of Criminal Procedure 1973, and an investigation to be carried out in terms with section 202 of the Code of Criminal Procedure of the said procedure code, finds it relevant to take note of the order which was passed by the concerned judicial magistrate. Kamrup at Boko in CR case number 51/2023. This court inquired with the learned counsel appearing on behalf of the petitioner, who submits that there is no order available. And in that regard, he have also submitted a petition before the concerned court.
That, my lord, that petition was not even accepted. This petition was not even endorsed.
Which have been enclosed as Annexure 5 to the writ petition, which have not been accepted. Under such circumstances, this court directs the registry of this court, more particular, directs the register of vigilance of this court to make an inquiry from the judicial magistrate first class, Kamrup at Boko, as to what order was passed in CR case number 51/2023, and from the office of the said judicial magistrate, obtain an order in the said case, which shall be placed before this court.
With due permission, my lord, item number 9 is also same.
But 9, let us come to 9 later on.
Obliged.
In this petition, my lord, the petition has been allotted some land, my lord, but that is with encumbrances, my lord. That has been under encroachment of the, my lord.
Encroachment of?
Other people, my lord, we cannot even enter the land, my lord. That's why, my lord, even some ancestral property, 2 parties there in the petition. Some ancestral property that is also under encroachment of some other people, so we cannot go there. Thereafter, my lord, this land of 14 biga, another 14 biga, my lord, the 7 family, that has been allotted. I have annexed the document here, my lord. But from 2023 onwards, my lord, after I have obtained a record, my lord, on this ground, but that is under the encroachment of other people, my lord. It is only simple prayer or submission, my lord, for demarcation, my lord, this property, my lord. We have also submitted an application to the authority, respondent number 4 and 5, my lord, for demarcating the land for the peaceful enjoyment.
You say on one hand, there is somebody else who have encroached the land.
Portion, my lord, not full.
So you want a demarcation.
Yes.
And for demarcation, why you are approaching the assistant settlement operation officer? Is the settlement operation going on in Kachar?
My lord, actually, my lord, without approaching them, my lord, as we have been informed, the petition have been informed, my lord, that there the you apply, you
No,
file.
no,
an
you have
application.
to apply. You can apply and get a demarcation certificate as per the revenue. There's a circular to that effect. That you can. But why are you approaching the settlement officer? Because is the settlement operation going on? He has no business otherwise. You should approach the DC, don't you think so? Madam, you have a circular no? Of this office memorandum pertaining to demarcation. Wherein it says what is the use of a demarcation certificate? Only to see the right and extent of the land and nothing beyond that. But the question is, if there is no settlement operation, why you are approaching the settlement officer, not the DC?
The boundary must be demarcated, my lord.
Understood, but settlement officer will only come into the scene when the settlement is going on. Otherwise, it is the deputy commissioner who has to do it.
We have been informed that third resettlement is going on, my lord. We
What?
have been informed, but no record with us, my lord.
The applicant has to apply in the standard application format before the circle officer of the concerned circle, and the circle officer shall endorse the same to the concerned dealing assistant copies. This is how it is done. The dealing assistant, after verifying, forward the AR to the lot mandal for field verification. Lot mandal submits the field report to the super for verification, and after verifying the report, forward to the circle officer Iman, and RIA approves, rejects the demarcation application. Once there is allowed, the dealing assistant prepares a notice regarding so and so. This is a procedure. Applicant must submit duly signed application form mentioning the details if the schedule dark, up to date land revenue payment. Then you have a circular office memorandum. You have not done it. Then dismiss.
On
Cost.
we may apply on format, my lord.
You don't approach this court like this. I'll in any application and come before this court. Hello, Lekok.
Are we allowed to withdraw, my lord?
The learned counsel appearing on behalf of the petitioner submits that taking into consideration that the petitioners herein have not applied in terms with the office memorandum dated 21/12/2020 before the circle officer of the concerned revenue circle wherein the petitioner's lands are located, the petitioner may be permitted to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. However, petitioners would always be at liberty to apply in terms with the office memorandum dated 21/12/2020. Yes, same types.
Same.
This is 50. Hey, আগৰ order to যে আছিল, okay, it 50 হ'ব, হয়নে? Mr. Goswami, earlier there was another 49. You see that earlier matter, just for example, item number 9 also, there is one communication issued by you. You have communicated that thing, means These are all same matters going on. Is there any merit petition pending? No. Why did you issue that communication? That is your letter.
Yes. Page number.
If that is what I am saying, page number
item number-
31.
Page number 35.
That is CR 49.
Yes, my lord.
This is 50 and 51. This is for 49. But what has happened in that case? Why did you issue this communication? Why?
I-
He cannot come up and say that there is a registration of some FIR.
No, my lord. In that case also, case was not earlier registered. It was only after the instruction sent to the officer in charge, my lord, they
No,
registered.
no, understood, but where is the question of registration? It may be that if it is the same thing, then under 210, if I'm not
Yes.
wrong, it may result in stay. That one proceedings may be stay if it results in the same thing. That's another aspect. But first of all, the court cannot do like this. We need to streamline this because tomorrow is another problem will happen.
Obliged.
Number 10.
Yes, I have filed this application against the respondent number 1 and 2, as they have not deposited the awarded amount. And it was, judgment was passed on 11/3/2016, my lord. We have then demand notice, then approaching also personally, and I myself also approaching, my lord. Then I have filed a Bakizai on 19/7/2000.
Who is to pay?
Now they have not responded, my lord.
Who is going to pay?
Our respondent 1, my lord, Secretary Home Department. And 1 and 2, who is, my lord, Superintendent APBN School.
And who is 3?
My lord,
3.
it is Kamru, my lord.
Respond number 3. Who is he?
He is driver, my lord.
Why are you making the driver party?
But driver is don't need.
Direction is given to whom?
1 and 2.
Then why are you making 3 unnecessarily again? Do you want the matter to be delayed?
Well-
Do you want the matter to be delayed? Then with the service upon the driver, it is
My
next to
lord,
impossible.
okay.
The direction is not upon.
Start on Respondent number 3.
Notice making it returnable on 23rd of September 2024. Who appears for 1 and 2? Home,
I have service notice, my lord.
you. Mr. Hezbollah, do you appear for 1 and 2? Huh? 2? Same. Yes.
This is 2.
It is under you only, Assam Police Battalion School. And this is also, department is also owner of APBN School. Mr. S. Burwa appears on behalf of the respondent number 1 and 2 and accepts notice. Extra copies of the petition be served upon him during the course of the day. This court is not inclined to issue notice upon the respondent number 3, taking into account the dispute involved in the instant proceedings. First, this court further duly takes note of the petitioner is aggrieved by the non-payment of compensation in spite of the award dated 13/11/2016 passed in MAC case number 1673/2009, whereby the respondent number 1 and 2 were directed to pay an amount of rupees 16,69,000 along with interest at a rate of 6% per annum from the date of filing of the claim petition. That is 28/9/2009 till realization. The respondents, number 1 and 2, are directed to file their affidavits on or before the next returnable date, stating as to why the said amount so directed by the award dated 11/3/2016 in MAC case number 1673/2009 have not yet been paid to the petitioner.
Second, their land is contemplating to take a respondent for the purpose of construction of road under Assam Mala project without acquiring their land also. Similarly, we found, as we got the August 2024, some person has come to our land by claiming the.
They have taken your land.
Not land yet, not taken yet.
Then
They are contemplating to take lots.
they will contemplate. If they contemplate, they will do it.
They put mark over our land. They put mark over our land. But
For what?
for the purpose of construct
Huh?
improvement and upgradation of road from Boroma to Nikasi, the Asamala project.
So they'll do it.
But without acquiring our land, without acquiring our land by procedure, they have in fact issued work order at page number 26.
The council, as of now, they have not taken your land. Neither possession of your land has been taken. Neither any notification has been issued. So under such circumstances, if you will be only aggrieved when your land has been taken without due process. So
They have put mark over our land.
you don't like the mark, remove it. That's your lookout.
However, when construction started from the initial point,
Understood, but has they taken your land?
not taken, but
They have not taken your land, they will take the land only by following due process.
our apprehension is that because they put mark over our land, so that
They'll take it.
any moment they can demolish our land.
What?
For house.
Under what provision? They will demolish. Under what provision? Yes, Mr. Naik?
Let them take a instruction. Lot.
No? Huh?
Then what you will see that.
That is what? They will take the land only when they require. And if they do it, they will always follow the due process. Isn't it? Then
Our apprehension is that because they come over our land and put mark,
remove that mark if you have. You have no business.
because they claiming to still belonging to PWD and mark over our land. This is our case.
Type of matters, no.
Then
Eh?
you will come. Lot.
Who is your senior? Ask him to come.
Next.
This can't happen. You withdraw whenever your land is being taken without following due process, you come.
Sometimes also my senior. But after time being also.
Your senior comes, you will impose cost for unnecessary spoiling the time of the court.
Hello.
Supplementary item 56.
Yes.
Lordship, in this matter, my name is not reflected in the court list. In fact, I have filed a Kalatnama today morning itself, Lordship. Allow me to argue the matter, then I will argue, Lordship.
Why are you appearing?
I filed the Kalatnama
When do you file your wakalatnama?
today.
So, how do you expect the matter was listed day before your name? What are you challenging?
I am not challenging anything. My prayer is simple, very simple.
It in the nature of sorcery should not be issued to setting aside an impugned resolution, and you are not say,
No.
you are not challenging.
I'm just.
Yeah.
Actually, there is a three-mode prayer, but I am not pressing all this one. Just I am praying the prayer that my appeal has to be disposed in according to the law within specific time limit, because the appeal, because Lordship will see in page number 92 that the appeal was on 8/8/2024. The date was fixed for hearing the appeal, but on that day the registrar was not available. But thereafter, no date is given. It is kept pending. In fact, it has gone to the cold storage. So my prayer is very simple and limited, Lordship. They may fix a date for hearing, the next day. Because already I have visited the office of the additional registrar of cooperative societies and registrar of the cooperative societies. I have requested them.
What
to fix
happened
it.
on 8/8?
On that day, the registrar was not available. He was on the casual leave. So nothing happened.
Did you request by signing a communication that kindly give us a next date?
Written. No written communication, Lordship. I have visited the office and I have submitted orally, requested them orally.
Basic philosophy of a mandamus is you have to demand.
That is true. I am not disputing on that, but from their part, from the part of the registrar, when someone is not
Mr.
available, the date
F-
is fixed.
F-
Jack Mojumdar.
FZ Majumdar that he would not like to press that. And instead, the petitioner would advise to a third of cooperative societies fixing a date for hearing of the appeal petition. Is given IDs fixing a date for hearing of the appeal petition dated 23/7/2024, submitted by observe that if the petitioner approaches the register of cooperative societies, said official shall duly fix a date that the appeal petition heard at the earliest.
For admission, item 12.
Yes, what is this?
The eviction matter, but unfortunately, in spite of the interim order, they have been evicted. Has been.
Have you filed any application seeking settlement?
Yes, my lord.
When?
Long back, my lord, page 44.
Page?
44.
Yes. And
Then, my lord, remand order was issued, my lord, but they have again,
now you have been evicted.
exactly, my lord. Some in other cases, my lord, your lordship pass order, hereafter he is also evicted together. Although interim order is there in this case, he is also evicted. Then dispose of the matter, my lord, to consider the application.
No, you
Lordship
file a
is-
proper application. Giving reference to this application, you file a proper application in terms with the land policy.
Land policy, my lord, that government was formulated land policy in the year 1989 for rehabilitation of landless person. of the state. Therefore, in
Now,
application.
you have already been evicted.
That will
So
not
under
be
such
very
circumstances, if you are an indigenous person, you are indigenous,
fine. Bora.
who is it?
Umashankar Bora.
If you are an indigenous person of, having requirement of land, file it. They will consider. Vasundhara Portal 2. 3. Or form number 12526. Otherwise, offline by, in a proper application you have, in form number 12526 ne kiba ase sab. Heard Miss N. Sekia, the learned counsel appearing on behalf of the so. Adam, you are there? So appearing upon the railway lane.
They claim to be, my lord. Nothing has been done till
You
now.
have been evicted under the Public Premises Act.
That day, my lord, some cases, 3 or 4 cases was before your lordship. Previous day, your lordship has had online, my lord, from my residence. That day I fell ill, having ill, and next day I could not come to court. So your lordship has taken up and dismissed the cases.
It's okay.
Thereafter,
No,
my lord,
I'm saying if it is railway land, that land cannot be given. You want to apply, you can very well apply.
disputed question, my lord, because the lower court has held the railway could not submit any document that this is their land. My lord, this is not a railway land. Till now here, they have done nothing. The land is falling vacant. 4 years back, my lord, it was during the lockdown time. It says it is not a railway land. But my lord, the railway claims that it is their land. He is having shop, my lord, not that.
Who has evicted you?
Railway police.
Railway has evicted you.
That's that, no.
So now railway have evicted you and you have not made railway a party.
Party is there.
No, estate officer cannot do that. No, estate officer cannot be a person.
So behind the back, there is a deep-rooted conspiracy. Set up a mall by the local element at that time. This 45, my lord, your lordship may kindly say, an RTI reply. Records regarding settlement of land. The station under the authority.
But Mrs. Nsukya, the learned counsel appearing on behalf of the petitioner, appears on behalf of the respondent number. Appears for respondent number. None appears for the respondent number 3. The petitioner has approached this court seeking a mandamus on the respondent number 1 and 2 to grant settlement of the petitioner in favor, grant settlement in favor of the petitioner in respect to the plot of land. Of land, which land? In respect to, in respect to plot of land.
Sir, Hosai Municipal Board.
No, what Dag?
Dag is my lord 465. My application at page 44, the Dag is the subject. line.
Dag number 465, which as per the petitioner is a government land. It has however been submitted that the petitioner who was in occupation of the said land have been evicted by the respondent number 3 authorities. In spite of when were you evicted?
During the lockdown period.
During the what lockdown were many lockdowns.
22, in the year.
22 there was no lockdown. 20 it is there.
21.
The year 2021. As the respondent number 3 is not present. Stop. Be that as it may, there is no instruction placed before this court by the respondent number 1 and 2 in respect to the application so submitted by the petitioner on 13/9/2015, taking settlement. What is your instruction? Huh? No idea. Mr. Barbuzari, you remember those cases in Hosai eviction? Remember? Hosai eviction, B.N. Gogoi was appearing for the railways. That happened sometime in 2022. Yeah. Good. Now, as per how a person needs to file an application under Form 125, 126 for settlement and or Basundhara 3 portal. Okay. Has no instructions. Taking into account that the government of Assam has already come up with a land policy of 2019, whereby there are certain policy has been formulated for settlement of land, as well as the manner in which it is to be filed. This court disposes of the instant petition, thereby granting the liberty to the petitioner to file to submit applications seeking settlement, taking into account that the petitioner is an indigenous landless person. File and submit an application, either in the offline or the online mode. This code also further makes it clear that the petitioner may also give reference to the application so submitted on 30/9/2015 as have been enclosed as Annexure 7 to the writ petition in its application. With the above, the petition stands disposed.
Please, your lordship. The earlier date when the matter was called before your lordship, lordship raised in query, my lord. Answering to that query, my lord, raised by this honorable court, my lord.
Are you getting benefits of pensionary benefits?
No, man. We are not,
CRG?
we are not getting anything, my lord. In this affidavit filed by us, my lord, in page 46, kindly peruse page 46, affidavit filed by us, additional affidavit. It's running. Para number 2, we have indicated, my lord, that GPF and AISPF fund of rupees 34,952 was paid to the petitioner many years ago, my lord. Thereafter, nothing has been paid to the petitioner, not a single penny. And my lord, on the earlier date, my lord.
No,
when
but
the-
are you entitled to for pension?
Yes, my lord, the petitioner was serving as an assistant teacher, ma'am. The petitioner's son, my lord, was serving as an assistant teacher.
But why you are not then moving that application then before the court?
My lord,
If you are entitled to pension, and why
kindly
the pen-
peruse Annexure A, my lord, page 49 of the affidavit in opposition filed by us. Here, we have submitted original survey books pension already forwarded,
This is done in 2024.
24, my lord.
9? When?
9/4/2024, my lord.
9/4/2024, it has been forwarded.
Yes,
But you will be entitled to pension.
yes, my lord. But the respondents are denying both the benefits, my lord.
Now, understood, that is
85 years.
another aspect to the matter. That is another aspect to the matter, but you would be entitled to pension. You will be entitled to the GCRG. If you have completed a particular, how many years of service did you have? Your son had?
Service, my lord. That instruction I don't have, my lord.
Hey, why you are getting incomplete instructions? Understood, but your case is as he is getting the pensionary and all these benefits, so he is not entitled to this expression. That's your case. Understood. There's no quarrel with that, but why I am asking him, if there's a reason why. That
Can't be
is okay.
possible for the petitioner, my lord. At this age, my lord. Point of fair.
The Borbujari one also has to take note of that petitioner is 77 years old.
Right.
If there is nothing out there, as it is your case, that he is not entitled to in view of the pensionary and all, why the appropriate direction for early coming of the pension and all benefits? That is what I wanted to see. After all, it is a cost of equity. No, no, you say that the petitioner would not come because he is entitled to benefits. No, no, there is a move for doing it. Education department is a party.
But my lord, I have a limited prayer before your lord. They are not saying that we want both the benefits. They're saying whatever we are entitled to, we make our prayer. my lord.
The instant writ petition has been filed by the petitioner, claiming benefit, claiming ex gratia grant on account of ex gratia grant in terms with the office memorandum dated 29/7/2006. It is seen that the respondent number 5 had filed an affidavit in opposition, stating inter alia that the son of the petitioner is being claimed that the petitioner had claimed that her son is a victim of extremist violence after he went missing on or after 6/1/2001. And the petitioner therefore claimed, hey, I got office memorandum dated 22/4/2004. Huh? The petitioner therefore claimed grant of ex gratia amounting to rupees 3 lakhs in terms with the office memorandum dated 22/4/2004. It was further mentioned that pursuant to the directions passed by this court in the order dated 3/6/2015 in WPC number 6521/2014, the rejected the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department by speaking order rejected the payment of ex gratia grant to the petitioner on the ground that the petitioner's son was a school teacher, and as per the office memorandum dated 6/6/1996, the cases of the government employees will not be covered under the purview of the said office memorandum, and the relief and rehabilitation branch of the Revenue and Disaster Management Department is not the competent authority to issue sanction for ex gratia grant to the family member / next of the kin. It was also mentioned that after the order dated 1/1/2016 was passed, the additional Deputy Commissioner Kokrajhar issued a communication to the District Elementary Education Officer Kokrajhar dated 5/2/2016 to requested to take up the matter of the petitioner for grant of ex gratia amount. In response to the said letter, the Director of Education, Bodoland Territorial Council, Kokrajhar, issued a letter on 31/5/2016 to the Commissioner and Secretary to the Government of Assam, Education (Elementary Department), and requested him to take necessary action for sanction of the ex gratia grant. It is further seen that there have been many correspondences issued by the Director of Education, Bodoland Territorial Council, for sanction of the ex gratia amount of rupees 3 lakhs to the petitioner. However, such request was returned to be again submitted to the Government of Assam through the welfare of Bodoland Department for sanction of the said amount. This court also finds relevance to take note of an affidavit filed by the finance department wherein reference was drawn to an office memorandum dated 29/7/2006. In the said office memorandum, it was stated in the said affidavit that it only related to families of state government employees, home guards, personnel of army and central paramilitary forces, CPMF, engaged in counter-insurgency operation in the state, if killed while on duty or in connection with the discharge of duty, as also the families of driver, handyman, and other employees of vehicles requisitioned by the competent authority for law and order and other emergency duty if killed due to attack of extremist or antisocial elements, and families of the state government killed due to hazardous nature of duty shall be paid the ex gratia at the rate mentioned in the said office memorandum. It was categorically mentioned that the said office memorandum is not applicable to the facts and circumstances of the instant case. On this matter was heard by this court on 30/7/2024, wherein this court inquired the rationale behind not granting such benefits to the petitioners, to the petitioner. In terms with the office memorandum dated 22/4/2004, which otherwise provided benefits to all the general public killed in extremist violence. It was submitted that the government of Assam have, on the basis of an intelligible differential, had categorized the government employees separately from the general public. The rationale behind this intelligible differential was on the basis that these government employees would be entitled to pensionary benefits, including the DCRG, etc. Taking into account the said aspect of the matter, this court, by an order dated 30/7/2024, and directed the petitioner to place before this court as to whether the petitioner have received any pensionary benefits, including the DCRG, on account of the death of the petitioner's son. To that, an affidavit has been filed on 8/8/2024, wherein it has been mentioned that an amount of rupees 34,952 was received by the petitioner on account of the death of her son, on account of GPF and AISPF fund, on account of the death of her son, but no pensionary or DCRG have been paid to the petitioner or any other family members of the deceased government employee. At this stage, this court finds it very pertinent to take note of that this is the second round of litigation. And the petitioner have been running from pillar to post for getting certain financial benefits on account of the for getting certain financial benefits. For getting the benefits for have running from pillar to post for getting the due benefits as per the various office memorandum as well as the pensionary as well as the pension rules. It is also to be taken note of that the petitioner is 77 years old. At this stage, this court finds it further pertinent to mention that an instruction have been placed before this court issued by the Joint Secretary to the Government of Assam, Department of School Education, wherein it is seen that a file had been moved for necessary views oblique approval of the compassionate family pension to the petitioner. So, in the said communication is kept on record and marked with the letter X. So, now, this court, taking into account the above facts, and the relief which have been sought for in the instant writ petition, is of the opinion that the interest of justice would be met if the petitioner, that in the above facts, the case as to whether the petitioner, as to why there has been a delay in settling the pensionary benefits and the DCRG be taken up by this court in the instant proceedings. Accordingly, this court, this is so done, taking into account the rationale behind which a government employee has been segregated from the general public. Accordingly, this court fixes this matter again on 11th of September 2024, on which date the council appearing on behalf of the Director of School Education shall apprise this court as to what is the present status as regards the status of the pensionary, the status of the pension status of the proposal as regards the pensionary benefits and DCRG of the petitioner. List accordingly, showing it as part of it. Something needs to be done.
And my lord,
I would, if it was a petitioner who is the wife, I would may not have. But you see, she's 77 years old. Again, asking him to file another petition would not be. And rightly or wrongly, there is a pensionary proposal pending.
Absolutely,
So
absolutely.
if she's, and the rationally behind segregating one party from the other is only on the basis of that they are going to get the
They are getting
CRG.
one benefit, yes.
And if it is so that the petitioner is not entitled to, then again we come back here.
Yes, my lord, definitely they will get, my lord. There is no denial.
one?
Pensionary benefit.
No, because his petition is not clear how many years he has worked.
That's
You see, if it is less than 10 years.
because by this petition, he is exclusively claiming only the ex gratia. He's living upon
Understood.
other.
Understood. There might, you never know, no? There might be a good reason why he's not going into that and filing a writ.
Only because of lordship's gracious intelligence and my lord, this issue has now sprung up, my lord. I am obliged, my lord.
Time being 11.
Yes, what is your case?
Lordship, this case, your lordship, in fact, what has happened, your lordship, the road was, they have started to construct. Your
So,
Now, your lordship, some the officials from the development, your lordship, came and marked our land, your lordship. Now, at any time, they can, your lordship, take over our land because your lordship.
what is your final relief you are asking?
My final relief is that they should resort to your lordship procedure established by law of acquiring the land. In Assam, Mala, your lordship knows that that guideline is there, your lordship, and that guidelines clause 4 says that first they will survey. Survey is done, your lordship. Thereafter, no action. In the meantime, construction has started, your lordship.
So?
Now, at any time, they may, now what happens, your lordship, in any cases, your lordship, the people had to come, your lordship.
Then come. As of now, why you are coming?
Lordship, because your lordship, yes, that is what I am submitting, your lordship. People had to come, your lordship. The agencies of the state, your lordship, sometimes your lordship acts in a high-handed manner. Now, your lordship, if they come and started demolishing your lordship without paying compensation, without following the procedure established by the time we came before this honorable court. That's why my only prayer before this honorable court is to ask them if they are going to acquire, then they should follow the procedure. If they are not, your lordship, then I have no claim. Lordship. That's only prayer, your lordship. Because your lordship, sometimes it happens, your lordship, that they come and started demolishing, taking over position of the land, your lordship. By the time we come,
Sometimes it happens, doesn't mean that it is going to happen to you.
no, your lordship, because your
This
lordship,
court is not going to exercise a writ on this man.
no, your lordship will kindly see your lordship. If your
No, no.
lordship,
If, but is not the question here. We are not on the question of if and buts. If and buts will be sometime later.
but your lordship,
You always have a liberty to come whenever something is being done. This court, how can this court presuppose that they are going to take any action, thereby not following the process?
because,
Merely making a survey doesn't make it.
no,
They are not going to do. You are saying you have enclosed out here to that effect. You don't seem to be having any objection as regards acquisition.
no, acquisition, we don't have any
So
objection.
under such circumstances, if they don't do it in accordance with law, you are always at liberty to come.
No, your lordship, why your
Because you see, Assam Mala is the project by which they can only do so if you agree.
lordship,
Assam Mala would not happen if you don't agree.
lordship.
Secondly, as regards the other aspects, if they go under requisition proceedings, Assam Acquisition and Requisition Act, they will have to issue the section 3 or section 6 notice. So without doing it, how do you say that they are going to do it?
No, your lordship, they
Or
have-
if this court says that we don't have faith in the state, they may go and do it, it shows a very wrong signal.
no, your lordship, I am not, your lordship, why I am submitting, your lordship, that they have started the process by, your lordship, identifying the land.
Well, you have no objection to the acquisition.
No,
So under such circumstances, if they don't do it, come back. We'll see.
but your,
As of now, why should?
this is because your lordship, ultimately, your
No,
lordship.
no.
come
Please,
and
no, Mr.
started
Bhattakul,
demolishing my properties, your lordship.
it shows a very wrong signal about the court not trusting the state. They may do or not. That's a different thing. But legally, as of now, how can this court presuppose that they are not going to do it?
No, your lordship, why I am submitting, your lordship. Had it been a case, your lordship, that survey has not been done, your lordship, then your lordship, what your.
Survey, if it is done, they may do it, and understood they may follow. How do you know that they are not going to
Why,
follow?
your lordship? Because your lordship, they have started the construction of the road, your lordship.
So what?
And the,
As of now, they have not done it.
no, started, your lordship.
You are always at liberty. If they do so without following due process, you can very well come. There's no quarrel. But how can you put an injunction prior to that?
Your
Why should
lordship,
this court at all entertain?
Our
Because
apprehension-
entertaining this type of repetition will have means opening the floodgates. Everybody will come. Oh, there we see they on one corner of the road they have started. They are going to take my land.
No, your lordship, why I am here, your lordship, this is because of the survey conducted by them, your lordship. Only to that extent, your lordship, if because of that, your lordship, survey is conducted, road is, construction of the road has started, your lordship. But this subsequent procedure,
Without an agreement, how can they have the Assam Mala project?
and in your lordship, that's what your lordship, our apprehension is, your lordship. In the meantime, they should have, your lordship, before starting the construction, your lordship.
I can do one thing. No interim, nothing. I'm
No, yeah, I'm
just,
not seeking
no,
any
no,
issue.
I'm only issuing a rule which will come up in another 10 years. In the meantime, construction,
Look.
interim order, you have prayed or not, I reject it.
The interim
them
order,
do.
I have not prayed. your lordship.
Absolutely.
My only, your lordship.
No, no,
my
I'll say that they can go ahead with doing whatever they like, and it will be subject to outcome of the repetition after 10 years.
Yeah. Yes. That
I
will,
think
your
this type
lordship,
of litigation
lordship,
merits
lordship.
such orders.
Then in that case, your lordship, I am not pressing this, your lordship.
Don't come up with this. I am giving you the liberty.
Lord.
If there is a transgression or an infraction of your right, we'll take
Lord.
care. The
Lord, that-
apprehension
that-
has
that
to be reasonable. As of now, can this court presuppose that this person concerned is going to violate the law? No. Or presuppose that the state is doing it. These type of orders can only be passed when this court has to presuppose that look here, the state is in such disarray, they do everything. Law and the state don't go together.
Lordship, I am with liberty, your lordship, may.
But Mr. Thakur, the learned counsel. ETC,
Lordship for 1, 2, 3, 4, and 5.
appears on behalf of
But 6.
7, you? 7 also, and 7. Mr. N. Goswami appears for the respondent. The instant writ petition has been filed by the petitioner apprehending that the respondent authorities have surveyed their plot of land, put certain marks, and they would be taking over the said land without following the due process. Mr. B. Chaudhary, the learned counsel appearing on behalf of the respondent, submits that the respondent shall only take action after following. Isn't it?
Yes.
Taking into account the above, the apprehension of the petitioner. The apprehension of the petitioner is totally misconceived, for which the instant writ petition stands closed as misconceived. Is misconceived, and accordingly the petition stands dismissed. However, it is made clear that the petitioners herein would be at liberty to again approach this court if the respondent authorities take any action without following the due process.
Obliged.
Petition is, my lord, against the order of the, my lord, control board imposing concession, my lord, 9 of rupees for an order.
Who has Pollution Control Board?
Violation of the statutory provisions. And just coming to the main, my lord, order, is that your lordship will come at page 226. my lord. 5th of
Which
September,
order? Page
226, and XRP 9. Page 226.
Yes.
Whereas under section 17 of the Prevention, one faction of the State Pollution Control Board, a comprehensive program for prevention control, of abatement so and so, whereas so and so, my lord, these are, my lord, things are there. Fourth paragraph where board has already issued public notice in Assam even on so and so, directing or applicant saying to install primary effluent plant and to make fully personal by so and so in compliance with so and so. Then I'm skipping this, my lord. Then next page also I am skipping. I am coming to page 228, my lord. That is our main part. Whereas the reply to Socor's notice is based on the facts and findings during inspection out on 6th of July and 8th of July by the engineer scientist deputed from the head office of the central laboratory of the board. Whereas reading operation for the following well completed.
Yes, what is your case?
Hello?
Your case.
Yes, my lord, here what happened? They have taken the sample, my lord, in violation of section 21, 22 of the Water Pollution and Control.
Water pollution.
Because,
Sample
my
they
lord, for taking sample, my lord, they have to issue notice. My lord, here what happened? Supreme Court direction with, my lord, install the primary, my lord, the PPT in 1996 itself. That is used as a common PPT. My lord, we are collecting the from the hillside and then there. My lord, now they have taken sample. Where from they have taken sample? Where what they have done? Not known, my lord. We have in paragraph, if you will also see paragraph 19, we have said everything, my lord, and they have not replied to that, my lord. Paragraph. Because on the basis of the, my lord, the report, my lord, we have a large number of hundreds of reports, my lord, all are. But only one report they have collected, I don't know, my lord, how.
Where is the show cause notice?
My lord, this is the notice, my lord. By on
No, that is the direction to pay. 226 is
that is
the
the-
direction to pay.
Yes, my lord.
This is not show cause.
No so-called, my lord, for the fine.
No. It was given. Whereas your reply to the show cause notice is not based on your page 228.
Fine, my lord. That is not for fine.
No. Kindly see
I'm
the
coming.
where the show cause.
Yes, that's right. I'm. My lord, that is at page 199. One nine. Second paragraph, they say, whether it is reported that there is no mobile ETP. Mobile ETP is not a compulsory, my lord. For treatment of effluent in post number so and so. Inspection officer registers has been observed that there is a seepage leakage in your streets, so and so wells, so and so, without treatment investigation. Whereas observed that during inspection, no precaution preventive measures taken to prevent the outside, speeds so and so, so and so. Whereas you are directed to install mobile ETB in the various station of the unit going without pollution control measures by discharging effluent nearby vehicles which affected the surrounding and cultivated to the air. Whereas there being no operation for such long time and there being responsible organization, you have to fail to comply with the basic provision of the Control Pollution Act. And therefore, considering the section 7 case,
So they have not asked you to close.
no, they have not asked me.
Hello?
Yes.
Direct him to close it.
Well, they have not asked me to close.
You are allowing them to run with fine.
They have taken some samples, my lord. Will be in violation of section 21.
Here he is going through the formalities of taking samples as regard the Water Act and all other provisions. Now, if at all we go into the technicalities of the matter, we will be skipping the measure issues involved in this case. Here, the measure issue is with regard to that, the direction contains in the Pariyaban Suraksha Samiti case in where the Supreme Court has specifically stated that all industrial units which require consent to operate must have a functional effluent treatment plant at the site. Otherwise, we have all SPCVs, that is the State Pollution Control Boards, have been given the authority
to impose environment compensation fine. And for that environment compensation fine, that methodology has been laid down by the National Green Tribunal in that subsequent order, which is part of the record. So here, based on that technical formalities and the methodologies that the Green Tribunal has addressed, we have issued the SOCOS notices. And as regard issuance of SOCOS notice, the Supreme Court is very clear that SOCOS notice can be given and placed at any public convenient places, maybe in newspaper, so that it comes to the attention of the violating industry. So that procedure part has been complied with. So that thing, they are not complaining anyway. So that has been complied with. After that, as an abundant caution, we have gone to the spot, we have taken the samples, we have given the analysis report, which proves antithetic, that is against them. So finally, this environmental compensation
But
fine
they
has
don't
been-
have a ETP.
Yes, effluent treatment plant.
They didn't have an
They
ETP.
didn't have it. They didn't have it.
And the Supreme Court mandated.
The Supreme Court, Supreme Court, that directives are very clear.
At page 65, my lord.
The Supreme Court direction is where?
Page 65, my lord. Your lordship may come to my lord, the para 4, para 3 and 4. Page 66.
Where?
4, para 4, my lord.
Effluent treatment, common effluent plan, so and so directed to and they didn't have a
They didn't have it.
ETP. Without ETP, they were running.
They were running.
They closed down.
So accordingly, this finance have been imposed and they have been asked to pay.
And,
But they have
finance will
approached the
give
court
it
and
as per
got
that authority. Because your thing is specific are two things. One is the
Effluent.
linkage of the well walls. The second is the ETP.
Yes.
Now, what do they say as regards, let's come back at 2,
Yes.
we'll take it up at 2:30. 2 o'clock, there are other 2 minutes.
Review of order dated 23/5/22. Notice may be issued, Lordship.
What's your ground?
Lordship, my ground is at page 9 of my petition. Firstly, Lordship, after the order was passed, I had filed a writ appeal against that judgment. And during the course of that writ appeal, certain facts were discovered which was placed before the Honorable Division Bench. But the Honorable Division Bench was of the view that since these grounds were not before your Lordship in the single bench, so therefore it would be better if I would file a review application. This is at page, Lordship, the order of the Division Bench is at page 55. It was finally disposed of on 19/3/24. Thereafter, Lordship, some 20 days time were taken in filing this review application after this date, Lordship. Lordship may see page 57 of the Division Bench order.
So when did you file this application?
This
Review
is on,
application?
this was on 2nd April. But since
2nd
your
of
Lordship
April.
was not sitting here, so it could not be placed.
Who is appearing for the other side?
Lordship, I'm appearing for 2, 3, 4, 5, and 6, Your Lordship. Notice may be issued, Your Lordship.
Where is the writ petitioner? Who is appearing for writ petitioner?
Lordship, nobody at the moment. I'll have to text. Lordship may allow me to text steps on the he responded number 1.
Who is the counsel for the writ petitioner?
Mr. D. Pangeng, I'm told he's out of station.
You don't have any junior of his?
Lordship,
You don't have any junior of his
uh,
in the court?
I think I didn't see anyone today.
Huh?
I didn't see anyone today.
Okay. We do one thing. We have it on what Wednesday. Let's have it on again on
Lordship, can it-
22nd,
Lordship,
22nd of August.
I'm sorry, Lordship.
22nd of, no, madam, listen, 22nd of August, you serve a copy. Okay?
Yes, yes,
As
Lord-
regards condonation of delay, we'll condone it. Don't worry.
yes,
So just give a copy to them. Okay?
yes. Lordship, can it be on another day because 27, Lordship, I'm very, I'm not in a position to, Lordship.
Okay, let us take it up on 27th of August.
Yes, Lordship.
This
Obliged.
matter on 27th of August 2024. But I cannot likhibo deই. Matter on 27th of August 2024. In the meantime, the counsel for the petitioner is directed to serve a copy of the review petition along with the interlocutory application upon Mr. D. Pangeng, the learned counsel appearing on behalf of the writ petitioner.
Obliged.
Okay? To serve it.
Yes, obliged.
Number 46, orders fixed to
Yes, what is your case?
So this is a decree passed under section 6 of the specific relief act. And that decree has been put into execution. So after the decree was passed, we prepared one CRP. My lord, so CRP has been admitted, LCR has been called for, it has been tagged with the CRP.
Which one? This one?
So this was laid before your lordship. So because of one reason, my lord, that the prejudice part could not be highlighted. Because of that,
But what are you challenging here?
no, we are not challenging anything. We are seeking protection of this honorable court. Because that our interest may remain protected till the disposal of the CRP.
Other
With
bit
regard
is
to
to
possession
state
matter.
the execution of so and so, which have been filed by the respondent to give effect to the judgment. You are challenging the order passed by the decree passed.
The past in the CRP. Now IA has been filed, that's for the protection that can be granted in our favor to protect the, so that our lawful possession remains in respect of this. And there is a parallel, there is one more suit pending, my lord. In respect of the same property, in between the same parties, that is pending.
And against what action have you taken against Mr. Nobodottor?
Against Nobodotto, my lord, one complaint has been made
What happened?
to the council, bar council.
What happened?
That probably has not given any result. My lord, Since some documents were missing, it was not filed by us, it was filed by the earlier set of council. Certain documents were required regarding his absence in the court while the process, the matter was fixed. So I have got the order sheet. Your lordship may kindly refer to the LCR, where it is apparent that he, without showing any cause, remain absent. This is the reason, my lord. The party remained unrepresented in the crucial stage. One is the evidence stage and other is the argument. Ultimately,
Who are you? You are the owner.
lawful owner of the land. One of the lawful owners.
You are one of the lawful owners of the land.
Yes, we are the lawful owners. We have purchased the land from the original Potadar. So original Potadar, that too after obtaining sale permission from the competent authority, my lord. And thereafter, sale.
Were you in possession?
Yes, we have been in possession and we are still in possession.
No, no, no. Now you are obviously in possession. That is why he has filed a suit. Were you in possession at the time when it was purchased?
Yes. Because of our possession only, title and possession, both the things are required. So based on that only mutation was granted in our paper.
Mutation, it is done. There's no quarrel with
And
that.
moreover, we have been in possession. We since the inception, we had been in possession. One more important aspect is there, my lord. The other side,
You have cross-examined
yes,
the PW1. PW2 was also cross-examined.
yes.
So,
We cross-examined, but we are precluded from filing our DW. It was fixed for DW, but our counsel did not appear. Then again, it was fixed for argument. Our counsel did not appear. My lord, whole claim of the other side is purely based on one particular document, my lord. That has been
what is that
a-
document?
an agreement, a Baina Poto. And this, I am having the certified copy. And this is a document based on which that other title suit is also filed. My lord, this document is a manufactured document. It is apparent.
No, but you have not asked for challenge. You have not challenged the document.
And we have challenged by way of counterclaim. By way of counterclaim, another suit has been filed against us, wherein they have sought specific performance of this agreement. And according to us, this agreement is a manufactured one. The lordship may kindly have a look.
No.
That's because signatures is pre-fixed. And then writing was done later on. It is apparent, my lord. And thereafter, in the last page also, in every page, writings was done later on.
There was also a sale permission.
There was also a sale permission that was also, my lord, manufactured.
So, but that challenge has not happened. Now, in that agreement for sale, whether it has been mentioned that he was in possession. In that agreement for sale, whether it was mentioned that the person to whom the sale would be made is in possession.
No, my lord. It was an agreement only.
Something will be given.
That specification is not there.
Why was this document then produced at all?
Based on this document, they sought specific performance of this agreement. And according to us, this one is manufactured. This instrument is not before this honorable court right now.
Yes, Mr. Sharma.
My lord, it is a suit under section 6 of the specific relief act. It is a suit under 6 of the specific relief act. And I am the plaintiff in the suit. And I am able to prove that I was dispossessed from the land. And I filed the suit within the period of 6 months. And the learned trial court held that the is in the time. And accordingly, the defendant side has not cross-examined 2 of my witnesses. And they have not adduced any evidence to counter my case or set up their case. Therefore, the trial court has rightly held that I was forcefully evicted from the suit land, and therefore restoration of possession was decreed. And their ground is mainly the advocate did not take any steps. But it is the duty of the defendant to contact the advocate. What the defendant did during that period. Only blaming the advocate will not serve the purpose.
So what is wrong with the appreciation of evidence by the trial court as regard PW 1, 2, and 3? What proof could you have given?
What proof they have given?
What proof you could have given?
Yes. They have simply stated that they have been dispossessed, forcefully dispossessed.
On
If
23/5/2016.
some genuine case is there would have been some police case, police complaint made by them. Since they said that they have been forcefully dispossessed. No, nothing of any incident of that can happen.
Why? But why didn't you cross-examine that aspect? You could have very well cross-examined them.
Because of the conduct. This is the reason we had to file this complaint, my lord.
You knew it then. Then also you knew it. At the time of cross-examination, you didn't. You means you are not bothered.
The reason, my lord, we are laymen. We engage a counsel.
Tomorrow that layman may implicate you also.
The reason and 2 crucial stages has been skipped.
So what? What evidence could you have given? I'm asking you. In spite of that.
Given that we have been in possession, my lord. We had been in possession. That was.
Show me what documents are there to show that you were in possession as on that date? Prior to that? 6 months prior to that,
Gampura certificate and everything could have been brought.
did you state it in your written statement? Let us see.
Written statement they have not annexed.
Why haven't you enclosed the written statements, Alfonso?
In written statement, my lord.
No,
Yes, my lord.
it's not such an easy matter. After section 6 proceedings.
Written statements.
I'll see this, no. I'll A. I'll A. When was your sale deed executed? When was your sale deed executed?
Executed, it was on 1st of January 2016.
How is it possible? Then at that point of time, there was also a sale deed permission going on. It was sale permission in favor of them was cancelled
Yes,
only
yes,
on
that-
2/5.
That was carried out behind our back. We did not have knowledge. Did not have knowledge. Because of that sale permission was later on cancelled also. Because there was a agreement to purchase 1 bigha some land by the other side. Consent was given for 1 bigha. That has been manipulated. And that was made 3 bighas. The original vendor, he himself appeared in deposed before the court. And one more aspect, my lord. Other side did not examine any official witness, nor did they examine any police or any Gambura authority. Only some individuals are examined.
What? What documents did you submit along with your plain written statement?
Our sale deed, permission, etc.
I don't see any document out there. Thing is there on record.
In support of our counter claim, we have made a counter claim.
Where?
WS itself.
In this case?
Yes.
Then?
Yes.
It's a different
others-
thing. I'm not on that.
others.
I'm only here. I'm asking you in this case, what documents did you submit? Because this is a suit of 2016. You were required to place on record whatever documents you wanted. Nothing. Then how can you bring any document of anybody or Gambura or anything?
Yes, that could have been brought in case we were.
Again
properly
blame
presented.
that lawyer.
Nothing like that.
Then?
Maybe simply our limited interest may be protected.
No
in the
limited
disposal of the-
interest. This is a case for limited means finally to dismiss your petition.
CRP, since the CRP or
CIP, we take it for dismissal now. Nothing is there. Why do we need to dispose of the other matter? You've seen the records, we'll dismiss your petition. Matter over.
in the CRP also, we want to bring some important documents on record by way of filing affidavit.
You can't file anything.
yes.
You have not brought on record anything while filing your defense, your written statement. You have not stated anything. You only said that these are false. Everything is false. That's all. I have a case.
Our this cell deed and other things are there.
Nothing is there.
Consonant with the bidding would have brought the evidence to disprove their claim. That has
How?
not been
How?
by examining witnesses,
What are the weaknesses?
by summoning the locals of that area.
So you must have given your list of witnesses?
Yes.
Yes. Did you mention anybody of your official witnesses?
So some lapses are there, I admit, but thing is.
Now you want to go back to the lapse of the filing of the written statement and not submitting.
One more thing, they have obtained the degree by playing fraud. Fraud in the sense that they are solely reliant on this, dependent on this particular
No.
instrument.
No, the court did not do on that. The court said that you could not show anything at the time of cross-examination. These people were cross-examined thoroughly. You couldn't get out anything. What is wrong? You have a right, file your counterclaim, X anything, do anything. If you are, produce your right title interest, recovery of possession, do whatever you want.
Till disposal of the CRP. We take that thing. If we are abstain from the possession. would not
You
be
want
able
that
to-
still disposal of the CRP, I will give you. But I'm disposing it now. Matter over.
Limited time maybe. Just
Limited
provided
time
to
I'm
me-
giving you.
provided
I've
to
heard
me,
you long
maybe
time.
Just to accommodate me, as because I am also newly engaged. So-
Fantastic.
So in order to accommodate me, some time may be allowed. Up to your lordship.
Hello?
Till that point of time.
Okay.
uh,
Taking into account we accommodate you till 27th. 27th August. 27th August. At the top of the list. Okay.
Yes.
So on that date, we are finishing of the CRP.
The record has been already.
I've seen it. Nothing, he doesn't have a case. So
That they will come prepared and will.
let us
Yes.
give him some satisfaction.
Yes.
Your name?
Arthur.
R. Sharma, the learned counsel appearing on behalf of the petitioners, and Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. G. Bhardwaj, counsel appearing on behalf. Today, the matter came up before this court for consideration of the application being IAC number 1962/2024, wherein there is a prayer for stay of the execution proceedings, being title execution case number 11/2023, which is presently proceeding. It has been duly informed to this court that the next date fixed in the said proceedings is on 21st of August 2024. In the meantime, this court, pursuant to the order dated, in the meantime, today, this court have duly heard the learned counsels for the parties at length and have also perused the materials on record. The learned counsel for the petitioner have sought for an additional opportunity to make further submissions. List the matter on 27/8/2024.
Can I make it on 29, madam?
On 29/8/2024. At the top of the list, showing it as part HUD. As this court is going to finally decide the the instant revision application. He is in the process of deciding the revision application. First, the respondent, the executing court, that is the court of the learned civil judge, Junior Division number 1, Albury, is directed not to further proceed with the title execution case number 11/2023 till 29/8/2024. You don't have a case. With cost. Yes, what is this? Punjab National Bank.
These gardens were put to sale, my lord, for recovery of the PF dues. Key states, my lord, Kipling and Rajabari, put to sale by the PF authority, ATEPFO, for recovery of the PF dues. Lords, we are the secured creditor in respect of the leasehold rights of both the tea gardens. We have challenged, we did not challenge the sale as such, but we only said that the dues that are going to be recovered from the auction, that is the auction money, let the PF take their dues, that is the workman's dues, it is the first charge. Balance, the balance that remains, that, my lord, should be disbursed to us, because the accounts have already gone NPA. We have already issued 13.2 and 13.4. And they have managed to sell the garden in item 48. But item 47, my lord, that auction has failed.
Who is selling it?
The Assam Tea Employees Provident.
Yes, you are selling it?
Yes, your lordship,
To whom?
by auction. We've got it's called Sham Tea Company. The deepling has been sold. And reserve price was 6 crores, we've got 6 crores, 3 lakhs.
And how much was your due?
Our due was about 1.5, the principal amount, plus interest. Interest is still being worked out for deepling. So,
What is your basis of fixing the reserve price?
a basis of fixing the reserve price was from the recovery officer, yeah.
Who is the recovery officer?
Recovery officer is the Provident Fund secretary.
No, is he going to decide what is the reserve price of a
Yes, your
tea
lordship,
garden?
that is the power under the act. Lordship may take a look at,
No, when there is other creditors whose entitlement is also there.
lordship, you take a valuation, nobody challenged the valuation. And it is under
Valuation,
the-
you
under
can't
the
have a
act.
valuation of whatever you feel like.
Oh, then somebody has to challenge it, your lordship.
Is what he's asking.
No,
for.
your lordship, there's no challenge
We are
to
not-
this,
we
to
did
the
not
auction.
challenge- We have not challenged it because this is the second round. Earlier round, there was also, my lord, the same challenge to the auction. And in that case, my lord, both the auctions failed due to lack of bidders. Now what has happened is that in second round, my lord, we are saying let the PF recovery its dues. We have nothing against the PF as such. It is the respondent number 2, that is the ATCL, which is the owner, so to speak, of the tea gardens. Which is ATCL, which is challenging our claim, and that is what we are against.
What claim?
So
As a
ATCL
secured creditor.
claims the right to have the balance of dues. Assam Tea Corporation Limited.
Which assumption, why are you agreeing?
Because, my lord, I am the secured creditor in respect of the leasehold rights of both the tea estates, and my security is now liquidated. Under the doctrine of substituted security, I have to have something, my lord. The accounts have gone NPA. Both the accounts combined, there is more than 6 crore dues. But they have managed to sell one tea estate. They have recovered around 6 crore 3 lakhs. That is what they have, the affidavit is there. Now, let them take whatever their share is there as a first charge. It's a workman's dues. I'm not challenging the workman's dues.
How are you making a claim against ATC?
ATCL, because, my lord, the dues have to be both these matters, leasehold right was mortgaged to us as a secured creditor.
Understood,
I have
but
to-
whatever may be, you need either two things,
Yes.
either initiation under the surface side. Now, what has happened there?
No, my lord, 13 to 13.4 we have done, but the fact of the matter is that in the meantime, the PFS has sold it.
Understood, but doesn't that,
Auction proceeding
no,
continues.
but doesn't the surface side proceedings have a Is taken at a higher pedestal?
Not it would, but under the Surface Act also, all that we could have auctioned is the leasehold price. We have not challenged the auction per se. We do acknowledge that PF has the right to sell it because the workman's dues take priority over all other dues, even perhaps over the Surface Act as a secured creditor. We are not aggrieved by the actions of.
But have you taken any action? Is it in pursuance to your action you are asking for the money?
Not only that, Manoj,
But
even
you
if
have
they
not
come
taken
with-
any action under 13.2.
Yes, we have taken action.
Now, what has happened there?
No, the action under 13.2 and 13.4 has been taken, and the
13.4, what
symbolic-
have you done?
a symbolic position has also been taken.
Symbolic position is okay, but what else have you done?
We could
The
not have done
symbolic,
it
it's just
because
a,
by the-
no, it was a company. Did you change the directors?
No, it was not a company.
TCL?
APCL is the owner,
Understood, it's a company.
but they are not the borrowers. The borrower was a private respondent who was a lessee of ATCL. Private respondent number 7. This is one Danish Kukurachua. One number 7.
Now, respondent number 7 had taken it from ATCL.
Yes, on lease for a 30 years period. And it was that, on the basis of that lease, that the mortgage of the leasehold right in both the tea estates was created in our favor. We became the secured creditor in respect of the leasehold rights for 30 years. And this mortgage was created with the consent and information of ATCL. Now, ATCL says that, no, you have nothing right over any of the, if anything remains, then you will take. That is what they have indicated in the earlier round of reflection when they filed their affidavit.
But how can you have a claim against ATCL?
But the claim is not against ATCL per se. The claim is against the asset. Asset, if the security is diluted, as in this case, then how do I enforce my security? The right of the security interest is gone now.
Go to DRT.
DRT, even if DRT issues a decree, it will still be a paper decree because there is nothing to enforce.
Understood, but decree, whatever may be, you are just a creditor.
Yes.
For creditor, it will be taken as if you, in terms with the manner in which the assets are to be distributed.
That is a separate proceeding. But here, DRT cannot do anything as far as ATCL is concerned because ATCL is not the borrower.
Understood,
Borrower-
that is why.
Yeah.
So the dispute between you and the ATCL is there.
Yes,
Whether
but
you
that-
are, whether you are entitled from ATCL or not, that is a question which has to be decided.
But that the tribunal cannot decide because the tribunal is there to adjudicate.
Why should this court decide at all?
So there is-
Whether you are liable, you are entitled to, whether the creation of a right by ATCL was there for giving you a mortgage for this particular period, or could that mortgage have been granted in this manner? These are questions of facts.
Here the only
Why
question
should this
is-
court go into all these
Here the
things?
question is limited, Manoj, that whether the doctrine of substituted security will apply in this case.
Understood. But that would have applied considering if it is only, the property only belonged to 7. But the property was only given, he was only giving a leasehold right of 30 years.
Yes.
But that 30 years, does it give the right for taking away the entire property? Making them totally, let us see the agreement entered into between this ATCL and the 7. Where is it?
But should we take up any identical rules? Item 47, Manoj, the 867 onwards.
Where is that?
The lease deed is at page 67.
Page 75, 67.
67.
Which clause?
Regarding the mortgage, but
Only come to 30,
yes,
30.
that if I may read. That in the event of the lessee's failure and or default to pay dues timely to the bank or financial institution, the bank or financial institution may suggest the lessor to allot the leasehold interest of the lessee for the unexpired period of the lease to another applicant who is in the business of running tea gardens and would have met the eligibility criteria of the RFP of the lessor at that time. And if such applicant is found to meet the eligibility criteria of the RFP of the lessor shall substitute the applicant as the lessee for the purpose of running the tea gardens and ancillary activities as per the extent guidelines of the Government of Assam. This leasehold right cannot be given because the property has been sold to recover the public revenue, the PF dues. This clause would not apply in this case. Question is this, my lord, that the lessor.
Now, where is the power given to this, the respond number 7, to mortgage the property to you?
Yes, it is given.
Where?
My lord, the clause 29, the preceding clause. Primary, this part. That if the lessee for the purpose of running and developing tea garden seeks to obtain loan from a bank or other financial institution by mortgaging its leasehold interest on the said tea estate in favor of such bank or financial institution, prior permission for the sale is necessary by the lessor and the industries, Commerce and Public Enterprise Department, Government of Assam to this effect, provided such mortgage does not affect the rights and powers of the lessor under this deed in any manner. Case of mortgage of such leasehold interest to the bank or financial institution by the lessee with prior permission of the lessor and the Industries, Commerce and Public Enterprise Department, Government of Assam for the purpose of taking loan or financial institution, such bank or financial institution shall have no authority or right upon the demised land itself. But we do not claim as such any right of the demised land itself. We security as such. As of date, my lord, there cannot be.
No security could have been created in your favor.
So security has been created only as far as the leasehold right. We are not.
Leasehold right is only for 30 years of using the land. It's just, for example, you are a tenant. A tenant is only the tenancy, right of tenancy has been given, nothing more than that. Then what right you have?
Now, even
No
as a
right.
tenant, Section 73 of the.
Yes, who is appearing for ATCL? None. He's not interested. He is not interested. You do one thing. You get the hold of that money and pay whatever is yours and give it to. The ATCL has no objection. Chalo. You dispose it of. You dispose it of. No, nothing big. You have not filed your affidavit also. He may give, he may do anything. These people, what right you have? You have no right over the land.
Over the land, we are not claiming.
And surface proceedings, how are you initiated under 31(5)? 7.
That. No, that is agricultural.
Tea garden is what? Tea land.
There are number of.
Leasehold right over tea land.
Sorry.
Leasehold right over tea land. And it's not agricultural.
Tea is outside.
Yes.
I can submit judgments to that. There are judgments to that effect. Tea, rubber, coffee, they will not be. The judgments of the Kerala High Court and other. But only one aspect of the.
Supreme Court? No, no.
High Court
We have a High Court judgment of 1984, wherein it holds it to be agricultural land. You see section 8. Agricultural land, you see section 10 of the Income Tax Act. Agricultural income is outside the purview. And tea is brought outside. And therefore, the tea garden, you have a different act for that. For Agricultural Income Tax Act. Only for that. So under such circumstances, why not an agricultural land? That's the,
That which will settle in a number of cases.
but you don't have a case.
The I would rely
You
on.
do whatever it is. You have any claim, you don't have any claim against the ATCL. ATCL has every right. Apart from that, they are the owners. No business out there.
Because then the security is, as of today, security will be treated as diluted because the security is gone as far as item 48 is concerned.
Catch hold of your managers who have given it in this manner.
Actually, listings is given in a number of cases. Tea gardens are not exempt, and they come under special cultivation. They are not under agriculture. That also common from a number of the exempt. The only difficulty arose when the lessee defaulted on the PF dues. Then the PF came into the picture. And my lord, the PF dues, we are not challenging that. They have the workman's dues.
No, they have the
They are-
first right.
They have the first right. We are saying
No quarrel with that.
our security as of date no longer exists. And my lord, this is also part
No,
of
no, you have no right. No. India has no public money business.
the section
Please,
73.
No, there's no public money business out there. To dismiss you, please.
Lordship may hear me on the section 73 part on some other date.
No, I'm dismissing it right now.
Section 73 will apply. The right of the mortgagor, my lord, to the right.
You have no right. You could not have no right could have been created by 7 in favor of you in view of that limited clause 29 and 30. That's all. Matter ends.
But that right is
So no right is there. You do whatever again. Catch hold of number 7 by his neck. Do whatever you like. But you have no right against ATCL.
that right has been created with the consent and information and permission of the ATCL.
But then also you couldn't have a claim over that property.
We are not claiming over that. We are claiming only the leasehold right. That is a common.
Understood.
as
That is
right
only
is
for
done
that.
in AIDC money.
You may have a claim as regards what is the legal right to that for use only? You may have a right of use over the land. You use it. But you don't have a right of claiming a share from him. No. A claim of share from him is a different thing because that is why the last line of paragraph number 29 categorically says that you don't have any right over the land.
The land, my lord, they-
No business of the land. So it is only a leasehold right, it's of a limited respect. Then you don't get any right.
Let me
We have done it,
satisfy
you've
your
done it.
lordship on the section 73 part on any other date. I'll submit whatever judgments
You have submitted.
I have not.
What else do you want to
On
submit?
section 73.
Huh?
Right, on section 73. The TP Act.
Section 17 of what?
73 of the TP Act, Transfer Property Act.
What is there?
The right of the mortgagee to the amount which remains. For instance, my lord, if the property.
Understood. But what they have sold is a different aspect. The right, it would have been there. Provided it is this 7 was the owner.
If it is not the owner. no. So
Definitely, that
70
is why your limited right is on leasehold.
But as of today, the security doesn't exist. So I cannot enforce my right. because the
Don't
security
do it. Also, there are a lot of things which the bank has been doing it. NPA.
Lordship will list it on any short date, no, I'll submit.
Interim orders?
There's only one interim order that they will not disperse it to anyone.
No.
The balance amount. Yeah, right.
Vacate it. We vacate all these interim orders. I'm not satisfied at all. Look. Heard
otherwise
Mr.
there
A.
is no
Ganguly, the
next-
learned counsel appearing on behalf of the petitioner in both the petitions. Ms. G. Goswami appears on behalf of ATEPFO. Admits that one tea garden have been sold, nah?
Yes, your lord.
Have been sold, and other tea garden is in the process of.
Yes. Fresh auction has been issued, notice. First round, no bidders. So again, on Saturday, there was fresh auction.
Bidder came and that was cancelled because the bidder withdrew from that.
Huh?
Bidder in item 47, as per their affidavit, bidder was there and
no
he was a
auction.
successful bidder, but the bidder withdrew from the auction. Whether they have forfeited that amount, that I do not, that is not.
You have no right on those.
Right,
Matter having, this court have heard the learned counsels appearing on behalf of the petitioners. Appearing on behalf, G. Goswami, something said one garden has been sold and the other is in the process of it. None appears on behalf of the respondent number 2. on the number 2. On call. It is seen that the instant repetition is directed. In both the repetitions are directed. Against the respondent Assam Tea Employees Provident Fund Organization, to the effect that that upon auctioning the tea gardens in question, the respondents, the said respondent should pay, should disburse the balance amount of the sale proceeds to the petitioner on the ground that they have, on the ground that the leasehold rights so created by, well, on the ground that the leasehold rights were mortgaged by the private respondent in favor of the petitioners. Prima facie, upon hearing the learned counsels, this court is not satisfied with the case set out, more particularly taking into account the agreement, the mortgage, the lease deed, so executed by and between the respondent number 2, that is the Assam Tea Corporation Limited, along with the private respondent. However, Mr. A. Ganguly, the learned counsel, submits that he would further like to address this court. Accordingly, list this matter on 31st of August 2024 at 2 p.m. Full stop. This court, in the facts of the case, is not inclined to extend the interim orders. Fantastic, let them do it. Whatever they do.
Only till 31st, till 31st of May will not be disbursed.
No.
Already, today we are.
No case made out. 29:30.
Till 31st, let them not disburse because it's a substantial amount. This is all, their money is also public money, our money is also public money. Let it not.
Is further make clear, however, make clear that if any amount is disbursed, the same shall be subject to the outcome. Disburse you. Yes,
Yes, my lord.
you don't have a EPL.
My lord, EPT.
Then
My lord is here. As per the report in 2017 directed, my lord, that primary ETP should be installed. But we have installed in 1996 itself, my lord.
no, they say on facts that you don't have an EPL.
So we are hearing, they say mobile ETP. Mobile ETP is not required, my lord. Mobile ETP, my lord, what we are doing, my lord, that that is primary ETP is a common ETP, and as per the central government guidelines, my lord, we are getting the yes, my lord, from those drilling sites to the primary ETP and doing.
What is this mobile ETP business?
Mobile ETP, my lord, it can be moved everywhere.
Then
My lord, only, my lord, where did
where is the judgment of the Supreme Court?
yes, my lord. At page 65.
Where is the direction?
Yes. Direction is, my lord, there at where are 4, my lord, where 7 and 8. 8, my lord.
In view of the fact that current position reference to the common and treatment plans, it was set up, we consider it as a director state government concern. They agreed to complete the same in the period 3 years from today. We have the opinion that common, but this is one. The another is, my lord, paragraph 3 and 4.
Now kindly come to paragraph 14 and 15.
Yes.
Why should this court entertain?
Supervisor complaints for non-commission of the instant direction. The benches concerned of the National Grand Tribunal will maintain planning for files and dividing the jurisdiction area into units. The above mentioned cases filed as a periodically, Pollution Control Board concerned are directed to initiate such civil or criminal action as may be permissible. Liberty is granted to private nucleus organizations that court to ensure. My lord, here Supreme Court directed two kinds, my lord. One is, my lord, that the primary ETP should be established by the.
No. Supreme Court said that we have given these directions.
Yes.
If there is all this implementation shall be looked into by the National Green
Yes, then
Tribunal
I said this judgment of the applicant.
and the Pollution Control Board, if there is a violation, shall initiate action.
Yes.
Now, anybody who is aggrieved by anything can very well approach the National Green Tribunal. This court at all interfere with all these things? We don't know. You go there. You are a big organization.
My lord, that here is a section of section 21-22.
Understood? Go there. Go there before the authority. When the Supreme Court have categorically mentioned, I would have understood the small industry of them, they may not have the area. You have the big offices out there in Delhi. Go there. This is not a case where you are going to file all these things. This is absolutely on these. If it is done in terms with these directions, isn't that, Mr. Borua?
Yes.
So if it is done in terms with the directions, if there is an infraction, you are aggrieved by any directions of the you approach the National Green Tribunal, they will give clarifications. Why should this court at all interfere? We are not an expert body to look into it. Whether 21 has been done in these simple cases that there is a requirement of having a mobile EPL, which is not there. You say that whether EPL is required or not, Supreme Court said something. So when specifically there is a direction to which the National Green Tribunal can look, why should this?
So what I am submitting, that so far Supreme Court is concerned that we have installed the ETP in 1996 itself.
Understood. So let the Green Tribunal look into it. Why should we look into it? The Green Tribunal is used with all these things. They know what is that, what is the parameters in which it is to be done. We are not an expert body. Green Tribunal is expert on these things. We are not approaching the Green Tribunal. The election is the Green Tribunal account.
But it's only there for 5 years, my lord. My lord, that this board only on the simple ground, my lord, that section 21-20 effects on, my lord.
No.
I can interfere in this.
And suggested. Where is the mobile area mentioned?
Why is my lord not there? It's Supreme Court judgment. My lord, there are two, my lord, primary and common. My lord, our primary ETP is there, which is used as a common entity. Some of the, my lord,
What is this mobile ATP?
why the ETP is, my lord, that it can move from this place to that place. That is, my lord, that is subsequently, my lord. We are using on contract basis for the, my lord, drilling sites which are at a distant place. In a galaxy, we have established a primary ETP, which is used as common ETP,
to the nearby dwelling units.
Yes, Mr. Borua, where is the question of mobile ETP?
The mobile, it will be in fact, they are confusing the entire terminology of mobile ETP and central effluent treatment plant. So here I would like your lordship to take paragraph 21 of my affidavit where I have narrated and made it very clear what makes the difference between these two. Because at the site before
Para?
transporting
Page,
para 21,
page.
is page 9 of my affidavit.
When did you file? Ended writ petition. Where is the affidavit? When did you file?
It has been replied on.
Yes. What did it say? Para 9.
11:20.
Para 9.
Yes.
Did not install any effluent treatment plan in subject of 6 drills, so and so. Hence environmental compensation. Where you have explained.
9.
9 doesn't say anything. Then why are you saying about mobile ETP in your notice?
Mobile ETP is before it is transported to the primary effluent treatment plant, they has to be processed. Here they are having pits where all the effluents go and gather and then it is overflowing and it is inundated into the nearby paddy fields. So here the pollution starts. So this is with regard to the analysis report which reflects the current positions when the analysis samples were taken from the site. This is the condition which the reporters have reported of the PCBA analysis report reflects. So that apart, we are only adopting the procedures as laid down by the Supreme Court and the National Green Tribunal. These are the these are the on-spot violations which they have been doing it. And for that matter, we have also enclosed the site reports and also the color photographs which goes on to reflect. And they have been asked to prove as regard whether this violation has been done on their part.